Hello. My name is Gerald Newman, and I am the director of the Human Rights Program here at Harvard Law School. My welcome to the audience in the room and to the audience online. We are privileged and delighted to be able to present to you today the globally renowned constitutional theorist, Dinesha Samararatne from Sri Lanka, who will be speaking to us on the subject of the duty to prevent guarantor institutions and state capture, theorizing from the global south. She will be introduced by our own highly accomplished LLM student, also from Sri Lanka, Manisha Dissanayake, and I will hand the proceedings over to Manisha. Thank you so much.
Hello, everyone, and thank you so much for being here, despite the end of semester fatigue that I'm sure a lot of us are feeling. So nice to have these conversations. And before I begin, I'd like to thank our sponsors, the Human Rights Program at HLS, the Program for Law and Society in the Muslim World, and HLS Advocates. I often describe Sri Lanka as a politically and legally unyielding terrain in which, however, groundbreaking human rights wins are made very, very often. There is a deeper consciousness among the judiciary, among citizens, among academics and litigators to really expand the frontiers of human rights and constitutional law protections in Sri Lanka. And this will be evident in the talk today as well. I also think this conversation is particularly relevant and critical today as the world is facing a crisis of leadership and governance. And in this vein, and without further ado, I'd like to introduce one of Sri Lanka's finest, Dr. Dinesha Samararatne. She is a professor at the Department of Public and International Law at the Faculty of Law of the University of Colombo. In 2023, she was appointed as an independent expert to the Constitutional Council of Sri Lanka. Very significantly, she is a former HLS LLM. Her research interests include judicial review, constitutional resilience, fourth branch institutions, and the relevance of the Global South in comparative constitutional law. Dinesha will begin with a presentation and then we can open the floor to questions from the audience here and also people who have joined us via Zoom. Over to you, Dinesha.
Thank you very much, Manisha. Hi, everyone. Let me begin by thanking Professor Newman, Abadir, for this invitation. I really must say, after about a decade, it's wonderful to be back. And preparing for this talk, I was looking back at my time in Harvard, 2008 to 2009, in what seemed like a different universe. I mean, obviously, I gained much from that experience, but in retrospect, one thing that stands out is that I think it gave me the added confidence to hold the line, as it were, when conditions for constitutionalism and for advancing justice have been weakened in the context that I have worked. So for that, I'm most certainly grateful to Harvard. Sorry, I will be clearing my throat as I go along because there seems to be some irritation. So I will be drawing on two aspects of my academic work, which looks at key developments in Sri Lanka. One is the emergence of what we call guarantor institutions. So think human rights commissions for now, and as we go along, I'll say a little bit more about what they are and what they do, and what we call a meta-guarantor institution. And these institutions have emerged in Sri Lanka over the last 30 years or so. So that's the first part. The second part, the more recent one, is what we call the crisis of representation that reached a boiling point in 2022. Now, initially, I had a gallery view of these developments, but as Manisha has already mentioned, since 2023, because of the work I do at the Constitutional Council, I've also had a inner perspective on some of the complexities involved in both these aspects of constitutional governance in Sri Lanka. Now, I'm going to use two ideas to frame these developments. One is the idea of guarantor functions and guarantor institutions, which Tarun Kaitan has introduced. And second, the idea of state capture, which was developed a while ago, around 2000, by Daniel Hellman and Kaufman. Additionally, and increasingly, I have been making a conscious effort to understand how living and working in what we broadly and contingently call the Global South, how that impacts the way I engage in my academic work, and also how it impacts the methods that are used to develop knowledge. So I'll be touching on that as well as we go along, and I'll be happy to take any questions during the Q&A on that. So this is what I propose to do in the next couple of minutes. I want to briefly recall the duty to prevent in the context of international human rights law. Very briefly explain the idea of state capture, because I'm not planning to build on it too much for today's purposes. And then introduce the idea of guarantor institutions and what we call the meta-guarantor institutions. And I'm going to suggest that these institutions have been a unique response to the problem of state capture in places like Sri Lanka. And please bear in mind, the story is far from ideal, but yet I think it's a very interesting story with insights for the dynamics of constitutionalism in the Global South. I also think these accounts allow for us to contribute to constitutional theory from the ground up, drawing from constitutional developments to speak to theory rather than the other way around. And finally, again, very briefly, I will suggest that there are a few other jurisdictions in the Global South that have had similar experiences and similar constitutional developments. So we all know that the scope of state responsibility for human rights has been described as including the duties to respect, protect, and fulfill. The duty to prevent has gained significance more recently, but I'm suggesting that its scope is much less clear, and I would dare say also relatively underdeveloped. Now, following some of the work that has been done in relation to the duty to prevent more recently, I think we can describe its scope as including primarily a proactive, positive, and direct duty on the part of the state, because it aims to prevent violations from taking place, and therefore mainly focuses on the obligations of conduct. In its operationalization, of course, we have to note that in relation to the duty to prevent, unlike with the other duties, perhaps the victim is largely unknown and perhaps does not yet exist. The duty to prevent also requires that there be clarity on the standard of foreseeability that we are going to enforce, as well as a standard of due diligence that we ought to apply. Again, these are ideas that I'm not going to speak to now. We can discuss it later if there are questions. For my purposes today, the key question that I raise is the following. In what ways does the state duty to prevent apply to constitutional design? And what I hope to suggest for you today is that new or revived constitutional institutions that amount to guarantor institutions can be a proactive, direct, and reasonable means of prevention of three things. One, human rights violations. Two, unconstitutional governance at a broader level. And three, at an even broader level, what I describe as state capture. Let me briefly explain my working idea of state capture. And like I said, we can pick this up later if there is time. The old idea of state capture focused on how non-state actors sought to capture the regulatory discretion of the state for their personal gain. And this work came out of the study of former Soviet Republican states. The newer idea, however, focuses on state actors elected or appointed through democratic and or legal means, and how they capture executive or administrative discretion and state institutions to advance their personal profit or gain. I just want to flag that my own thinking on the duty to prevent and state capture has benefited enormously from a project I was part of at NYU at the Center for Human Rights and Justice. So looking at the duty to prevent and state capture and my own context, this is how I'm now trying to build this argument. So let me explain the main ideas at play here. So in places like Sri Lanka, constitutionalism and scholarship on constitutionalism does not say much about corruption. Yet, in places like Sri Lanka, corruption is not just a significant but also an intractable problem. So I try to use the duty to prevent and state capture to yield the following analytical purchase. So first, I think this approach helps us to take the Global South jurisdictions on their own terms and have a fresh look at issues that are more common in such jurisdictions, such as the crisis of representation, bankruptcy, state failure, and the impact of agreements with international organizations like the IMF on constitutional governance. I mean, there's a different conversation to be had about how this kind of thinking now has global resonance, but again, that's for another time. Relatedly, this lens also helps us to examine systemic corruption that can take place through democratic and legal means by state actors themselves, and thereby, again, implicating constitutional governance. So this is the core claim. While the issue of corruption and state failure has endured and arguably compounded in Sri Lanka, what we have also seen in Sri Lanka in the last 3 decades or so is the emergence of guarantor institutions. And as I will explain to you shortly, they emerge out of a very interesting contestation among political actors as well as the people. Studying these arguments, the core argument I want to present is that to ensure that the state serves the purposes it is meant to serve, state institutions ought to be designed to prevent state capture. And one way perhaps of preventing state capture, I want to suggest, is to include guarantor institutions as part of its constitutional design. And like I said, I began studying this in Sri Lanka, but I'm beginning to see similar resonances in a few other jurisdictions as well. And I just want to flag that guarantor institutions themselves, of course, can be subject to state capture, and we've had some experiences in Sri Lanka of that too. So in essence, guarantor institutions perhaps can be a response to the problem of crisis of representation and state capture. Now turning very briefly to the Sri Lankan story. So at least from 1978, a key constitutional issue that we have faced is the abuse of power in a semi-presidential system. We have a significant body of academic work and jurisprudence which reveals the way in which the office of the executive president in Sri Lanka has undermined constitutionalism and weakened checks and balances in the system in a systematic manner. It is perhaps, that is the office of the executive presidency, the most significant factor that led to the crisis of representation and bankruptcy that manifested in 2022. Now, back in 1990, a presidential commission that inquired into the second Marxist youth insurrection that had just taken place proposed a nominations commission as a means of depoliticizing appointments to several institutions, such as the Public Service Commission, to which appointments were being made at the sole discretion of the president. This idea was included in a draft constitution of 2000. That constitution never passed, but the concept of the Constitutional Council endured. But since then, as you can see on the slide, what we have is elsewhere what I have described as constitutional ping pong. This Constitutional Council is introduced, it's repealed, reintroduced, repealed, reintroduced, repealed, and reintroduced. And in that process, we see a pattern. Whenever the executive presidency is strong, the Constitutional Council is repealed. Whenever the executive presidency is not as strong, civil society has a greater opportunity to compel greater accountability, the Constitutional Council has been reintroduced. Essentially, this Constitutional Council does two things. One is it recommends names to the president for appointment to constitutional commissions. Second, it approves or disapproves recommendations made by the president to key constitutional officers, including the appellate judiciary. And its composition is very interesting. It is multi-partisan and includes civil society representation. So it has the speaker, the prime minister, 2 nominees from the government, 2 nominees from the opposition, leader of the opposition, and 3 people like myself. So it's multi-partisan plus independent representation. Okay, now let me very briefly say something about, I'm not going to speak to this today, Guarantor Institutions and the theory behind Guarantor Institutions. So they are designed to uphold what Tarunab Kaitan describes as non-self-enforcing constitutional norms. These are norms which political actors have no incentive to uphold. Examples include human rights, electoral integrity, and transparency in procurement. They may also, however, deal with norms that political actors in the opposition have some incentive to maintain in order to ensure that there is political competition. In this way, these institutions are designed to uphold and advance certain constitutional values such as independence, expertise, and criteria-based appointments. And as we know, not just in Sri Lanka, but elsewhere as well, since the 1990s, we have seen the emergence and proliferation of these types of bodies, such as human rights commissions, election commissions, commissions to deal with bribery and corruption, etc. Ensuring their independence and competence is a challenge in practice, but this is the, I would suggest, the thinking that goes into designing these institutions. So this brings us to what we can describe as the guarantor function, arguably a function that is pulled out of the more traditional functions that the 3 branches of the state carry out, that is the executive, legislature, and the judiciary. In contrast, the guarantor function is focused on a single norm, and these bodies are separated out from the executive, legislature, and the judiciary. But in performing their tasks, they also carry out some administrative functions. So they have subordinate legislative capacity and also quasi-judicial powers. Now, interestingly, these types of bodies require different type of personnel. Unlike the kind of personnel we have in the executive, the legislature, or the judiciary. They ought to have high-level expertise in relation to the non-self-enforcing constitutional norm, but they must also possess, ideally, certain dispensations if they are to carry out their tasks independently. Again, we can discuss this more if there are questions. Now, guarantor institutions is the more common development, but the Meta and the Chapter 9 institutions of South Africa are a case in point. But what we find in places like Nepal, Sri Lanka, Seychelles, and Fiji, although their practice is far from ideal, is this idea of a meta-guarantor institution. And in both in Sri Lanka and Nepal, this body is named as the Constitutional Council. And I think the main purpose of this body is to bring in a different type of decision-making process, primarily multi-partisan, and to ensure that the appointment process to guarantor institutions themselves is more independent, criteria-based, transparent, etc. So there are 3 approaches to designing these kinds of meta-guarantor bodies. Either have a different set of combination of elected representatives, or elected representatives and high officials, or elected representatives, high officials, and civil society members. They can, a meta-guarantor body can perform several functions, and I've tried to list out some of them. It can be administrative, it can be to do with communication within and externally, and more importantly, it can focus, I think, on developing the guarantor functions and the norms. Right. So as I said very briefly, there are a few other jurisdictions in the Global South which also seem to have meta-guarantor institutions. The practice under these institutions, from what I can see, has been difficult and, like I said, far from ideal, but there are some interesting parallels that we see. One is that they have been created and established at a point of re-democratization. They have also been brought in with a demand from the people, and I use the term people very broadly here. And it seems to be an attempt to push back against the abuse of power, often by the executive. So in that sense, the Sri Lankan story does seem to have resonance elsewhere in the Global South. Right. So to sum up, conceptually, we now recognize that states have a duty to prevent human rights violations, although the exact scope of that state responsibility is not clear. When key constitutional institutions, such as an executive presidency, undermines constitutionalism and operates to capture state institutions, including institutions that are supposed to function independently, such as the judiciary, what solutions can we find? The experience in Sri Lanka and the few other jurisdictions that I have referred to suggest the following. One, as we all know, several states in the global south are faced with issues of systemic corruption, state failure, and crisis of representation. Establishing independent bodies, such as the Human Rights Commission, is perhaps one design method to create the possibility for human rights protection in such contexts, and this method seems to have been widely used by those seeking to advance democracy in these contexts. To protect these institutions, these guarantor institutions from politicization or capture, in a few jurisdictions, a meta-guarantor institution model seems to have been used. And again, the practice is far from ideal. The emergence and work of these institutions, that's the guarantor institutions and the meta-guarantor institutions, suggests that drawing out and strengthening the guarantor function of the state through institutional design could be one method for fulfilling the state obligation to prevent, the state obligation towards the duty to prevent. And finally, these constitutional developments seem to be a unique, democratic, and constitutionalist response to some of the intractable problems we face in relation to constitutional governance in the global south. Thank you.
Thank you so much, Dinesha, for that presentation. I'd like to actually open the floor to questions from the audience at this point. I know that often at lunch talks, we wish we had more time for questions from the speaker. So we'd like to hear any questions that you may have. I think we can also accommodate questions via Zoom, Abadir. Yeah. So yeah, the floor is open for questions.
Hello, now, yeah, I can hear myself. Thank you very much for being here and sharing this with us. This is really insightful. And I was wondering, how do you think this relates or how this is reinforcing or talking with the development of the pillar of guarantees of non-recurrence in transitional justice as a development-like field or the least developed field of transitional justice right now? And maybe your thoughts about like the difference that there exists like in the theory around negative peace and positive peace. Yeah, thank you very much.
Happy to respond to that, yeah. Thank you, that's an excellent question. So the design response would be to design specific commissions that can deal with the issue of provide policy responses and practical responses to the issue of non-recurrence. And then through, in the Sri Lankan example, use a meta-guarantor institution to ensure that appointments to that body are made through a criteria-led, independent, transparent process. And there, as you know, any issue related to transitional justice is always heavily contested and politically extremely sensitive. So political actors would often be very hesitant to allow such a commission to work independently. So I would even venture to say that even if you have a meta-guarantor institution, the chances of ensuring that the best people are appointed to such commissions and that they can work independently are not necessarily very high. But the chances are relatively better than if you do not have a process which is multi-partisan, criteria-based, and transparent, which also generates confidence in the appointment process. But that is only the beginning. You then subsequently also have to think of accountability of that body, supervision for that body, which at the moment, from what I can see, none of the meta-guarantor institutions engage in. The other response I have is about how even arguably a well-funded commission with a strong mandate and independent, competent commissioners, even for such a body to work, you still need to have an executive and a legislature and a judiciary that works reasonably well. For instance, the legislature drafts the law that sets up such a commission. So competency of the legislature matters greatly in order to make sure that the mandate is presented in a way that is not just fit for purpose, but also practical. One final thought, I think, there's a lot that has been said about guarantor institutions or independent institutions in order to present them as a strong response to issues of constitutional governance. But I think each jurisdiction has to assess for itself as to where the saturation point lies. So you cannot have commissions upon commissions in a jurisdiction. I think there's a saturation point. Beyond that, these bodies might end up very well being not effective in what they're supposed to do. Thanks.
Okay, thank you so much, Professor. I have two questions. So the first question is, I would appreciate it if maybe you can share some examples of like how the Guarantor Institution in Sri Lanka, how it played a role in like maybe protecting democracy or like promoting human rights, like maybe specific examples regarding more recent developments in the country. And my second question is, I think it's really meaningful that these guarantor institutions have like alternative ways of selecting their members from other majoritarian branches. But I was wondering how do you ensure that maybe like more minority interests or interests that like or interests of people or groups that are really having a hard time mobilizing or being actors in like already existing political processes, how do you ensure that these interests are reflected in these guarantor institutions? Thank you so much.
Great, thank you. Again, two excellent questions. So even though I can take examples from the present window, because I'm also involved in one of the bodies, I'm going to take examples from the previous cycle we had, 2015 to roughly 2019. During that period, Sri Lanka had what we call a constitutional crisis. The president removed the prime minister without constitutional authority and attempted to dissolve parliament. In that moment, the role of the election commission revealed to us that having and the election commission had been appointed through the constitutional council process, and it was in fact the first election commission Sri Lanka ever had. The election commission was brought into the constitution in 2001, but it was never appointed. It's only in 2016 that it was actually appointed. And if you look at the role of the election commission during that constitutional crisis, it demonstrates, I think, quite effectively how state authority can be used in an independent manner that is independent from the executive and the legislature in order to ensure that a non-self-enforcing constitutional norm that's periodic and regular elections at the correct time are upheld. But I must also, to be fair, say that we also have a very interesting example of a human rights commission that was not appointed in this way, acting quite independently during 2022. So all this to say that context matters greatly, and there are path dependencies, but there are also the unexpected developments that can take place. And I think that connects us back to this question about the personnel. More and more, I'm drawn to the question about the kind of personnel we need to work in these commissions and the way in which they are able to hold the line or not. So I think the Human Rights Commission between 2020 and 22 is an example of a commission that was not expected to serve independently. In fact, it was downgraded internationally, but played an extremely significant role. To answer your second question, the design response would be to say each commission must include representatives from the different ethnic communities, must ensure gender representation, depending on the sort of the pressing issues of each jurisdiction that can be brought into design. But as you know, it can very well be something that is done as a symbolic gesture. How do you address that? I'm not very sure I have answers for that. And then we also go back to the other question about representation, inclusion, whether institutions, so in my view, institutions must ensure inclusion, representation, but substantively too, we have to respect diversity and inclusion of minorities, women, etc. And sometimes that can happen even when there is no so-called representation. So all I'm trying to do is complicate this for you a little bit more, but certainly there are design responses that can be made. Thank you.
Hi again, and thank you very much for being here. I really enjoyed the talk. I had one meta question that I'm decided to break down into two smaller questions, but and I wanted to ask about what do you think are the limits to guarantor institutions playing a healthy role in a democracy? I think I see at least two broad categories of limits. The first is limits to what the law can do in a way, because it seems to me like, and I think you might have touched upon this in your previous answers, but the guarantor institutions are supported by norms as much as law, and there is a point to which what would prevent, for example, meta guarantors from being captured themselves if you don't have like other values in a society. And I think Professor Tushnet has made the argument that guarantor institutions work best where they're less needed or something along those lines. So that's like, what do you see are the limits in that sense and what law can do? And the other question is, what are the limits in, or what would prevent us from just like enlarging the menu or catalog of guarantor institutions to try to correct every single failure that we perceive in a democracy? Like, should we have a guarantor institution for, I don't know, information or education, or I don't know. Do we need a independent human rights commission if, I don't know, constitutional courts are performing certain guarantor functions, or et cetera? I think you get the point. But so that was my big question. Thanks.
Again, great questions. Thank you. So I think Tushnet makes several interesting arguments, and I must say they are quite persuasive. I think at one point he says it is when political parties are sort of acting contra constitutionalism that you need guarantor institutions, but that's the very point at which you can't really have institutions working independently because of the problem of state capture. I'm trying to see how best to answer it in a short time and also publicly. So again, going back to Sri Lanka's story, this is why I referred to this whole thing of constitutional ping pong. What you see is, like I said, a strong executive presidency taking the Constitutional Council out of the constitution, making sure that there are no conditions for commissions to act independently. And then there is pushback, democratic pushback. And 2015, 2022, we see the Constitutional Council being brought back because there was this, I mean, I don't want to romanticize what happened, but because there seems to be this largely popular demand for these bodies to be brought back. So I think, at least in the case of Sri Lanka, guarantor institutions have represented democratic aspirations, but short-lived. So what we are seeing as the limits to guarantor institutions is that they cannot exist in a jurisdiction where the executive or the legislature will not allow them to function. That is the reality. So at some level, there has to be recognition and support from the executive and the legislature, even in terms of saying we will not interfere, we will not push back too much on the guarantor institution. So there has to be a live and let live kind of understanding among the institutions. And all of this is beyond the law. So even I think what happened in 22 was the Constitutional Council was brought back without much expectation of independence of that body. And again, I don't want to comment on the work of this council because I'm on it. But you go back to the question of personnel. So personnel who are appointed to these bodies, I think have a significant role to play because these are this is the early stages of new institutions. So in new institutions, at their early stage, personalities matter and they determine the perception of the institutions, the way in which the mandate is to be interpreted, and the way in which other state institutions will perceive the new institutions. So in Sri Lanka's story, we don't know whether in the next year, few years to come, the council will be taken out again, or whether it will consolidate. So that will be a good indication as to the strength of a guarantor institution. I certainly don't think there should be a proliferation of guarantor institutions. That's why I said there is a saturation point. Where that saturation point lies will depend on each context. I'm also a strong believer in the democratic process and the need for the legislature, executive, and the judiciary to function meaningfully. So in that sense, it's the collaboration across the executive, legislature, judiciary, and the guarantor institutions that will help the state to serve the people. So that is the ideal. I have not yet worked out the way in which we can know when we have too many guarantor institutions. Thanks.
I have a question from online. Sanjit Diaz asks, would you say guarantor institutions and meta-guarantor institutions suffer from a lack of legitimacy because they are unelected? How can they be designed to or discharge their functions so as to increase their public legitimacy?
And there's another question from the back as well.
Do you want to take the first one and then I can speak?
All right, okay. So thanks, Sanjit, for that question. So I would argue that the legitimacy of guarantor institutions should not come from a democratic process. The very idea of guarantor institutions is that their legitimacy comes from expertise and distance from electoral or representative politics. And if we look at how the Right to Information Commission or the Human Rights Commission or the Election Commission has worked in Sri Lanka and the people's engagement with those commissions, we see that there is a fairly high degree of acceptance and engagement. And in a society where there is a crisis of representation, I think people are more drawn to non-elected state bodies because they tend to feel that at least through these bodies, there might be a better response to some of the issues that they face. Having said that, I do think that these institutions can be strengthened further in terms of their public legitimacy. But that then goes back to the answer I gave to the earlier question. It is also about consolidation of these bodies. So in Sri Lanka, the Human Rights Commission, Election Commission, and I think the Right to Information Commission certainly has gained a lot of traction. So for instance, I don't think it will be possible for a government to say we are going to abolish these commissions. So time is also an important factor. With time and the performance of these commissions, public legitimacy can be gained. Thanks.
Thank you so much for this talk. This took me back to my work like 6-7 years back. I used to work on police atrocities in India. And one of the things that I looked at was police oversight commissions. And I guess that would also be part of what you are calling a guarantor institution. And similar to election commissions or Women's Commission, Human Rights Commission. One of the biggest criticisms for some of these bodies, especially for the human rights body in India, the National Human Rights Institution, is how toothless it is, and it's hard to implement what decisions the commission actually comes out with. I guess I have a few thoughts on this. And the second one, composition, like you say, is such an important factor because a lot of the times these institutions become sort of resting places for a lot of retired government servants, whether they are civil servants or judges or politicians. And in that sense, I don't know who's listening to this, but I'm very cynical about how they approach this kind of work, and they don't really stay nonpartisan or extremely invested and interested in how they come out with this. And I understand that in the states that you have chosen, they are states that are coming out of they're transitioning from difficult periods, conflicts, civil wars. And India is definitely certainly a different case in that scenario, but also thinking ahead in terms of sustainability of these commissions, I think it's important to think about how they can sustain after, say, 50 years when the countries think they're in peace and all of that jazz. So I guess in terms of that, one is how do you see that working out in the long term, especially in societies as divided as ours and with such different histories that we have in South Asia? And the other one is also that you spoke about constitutional designs. So the police oversight body that we worked on, it was a creation, I would say, from the judiciary. It didn't come from laws in specific, but from a lawsuit that was filed by a retired police officer saying these are the issues with the policing system in India and how do we address this? And one of them was police accountability. And again, there's a question of how much should a constitution contain, and especially when I think about how India's constitution is like the longest constitution in the world, how much do you put in within the constitutional design and how much of it should be out of it, and should a judicial creation of this sort be allowed? Yeah.
Fantastic, thank you so much. So police oversight in terms of appointments, transfers, and promotions, as well as disciplinary inquiries, can be part of a guarantor institution, can be the mandate of a guarantor institution. Again, I too am mindful of how much I should and should not say. In countries which, so if you are looking at a country that is facing a crisis of representation and has corruption, you can imagine how difficult it would be to have an unelected body of experts providing oversight for the police, right? So in my view, if you look at these guarantor institutions and categorize them, I think there are some which can function relatively well, some which will find it extremely difficult to function. And there are different factors that at play. So with human rights commissions, even the fact that there is international engagement, I think often helps domestic national human rights institutions to function. Whereas with, say, police commissions, it's very different, and the subject matter goes into the heart of the contestation within the state. Yet, I think having the institution gives us a prospect for demanding for enforcement of the non-self-enforcing constitutional norm. So that is where you start with. And where commissions are not effective, I think, again, you have to go back to the drawing board in thinking in terms of what is the public response, how can the judiciary respond, and I would imagine that the executive or the legislature will not be too unhappy when a commission is not powerful. So it's left to the other sectors of society to try and respond to that problem. But my hypothesis is that police commissions would find it generally hard in the kind of jurisdictions that we're talking about. You are absolutely spot on about the kind of personnel that get drawn to these institutions, because if they are not elected bodies, if they're only for a short period of time, 5 years, 3 years, if they require expertise, you are naturally limited in terms of the pool that you're looking at. So that is a significant issue. So for instance, in Sri Lanka, if you want to be considered for the Right to Information Commission, you had to be willing to not engage in any profession or job for the duration of that term. So if you're thinking of an expert on the right to information, say for instance, a lawyer, it's a huge sacrifice for 3 years to not engage in other types of employment and to only be in a commission, and a commission that's not going to pay you a significant amount of money. So the details have to be worked out much more, which is why I made the comment about the legislature. So the legislature provides the mandate for these institutions. So unless the legislature is informed, sensitized, and is mindful of the guarantor function, of how a guarantor institution should function, and the broad idea of duty to prevent, we will have problems. The future of these commissions. So I am not someone who thinks that institutions must last for eternity. If we are looking at jurisdictions which have a certain problem, so in my case, I presented 2 problems, corruption and the crisis of representation. If we can foresee a possibility for these problems to be addressed in a meaningful way, maybe there is no need to continue all these commissions in the same way. Maybe there is a possibility of reviewing, revamping, readjusting. I don't think we should be, I think we should have that option on the table as well, but I certainly think right now is not the moment for that. Thank you.
Thank you so much for being here. I wanted to wait because I have very long-winded and very several questions on this subject. So the first one would be that whether you would consider there to be a requirement for a normative commitment to what jurists and legal professionals would deem optimal values for a guarantor institution to be regarded a guarantor institution. Because when we were talking about guarantor institutions and when I was scouring the literature for it, one of the first ones that came across was the Guardian Council in Iran. And I don't know, again, who's publicly listening to this, but I wouldn't agree with the values that they're guaranteeing within their constitution. But I think you could make a functional argument that they're doing a very good job in guaranteeing the said values. So is there a threshold or a bright line for what a guarantor institution could be normatively committed to when they're being a guarantor? Or is it up to subjective determination based off of the scholars or the legal professionals? My second question in this regard would be whether you would consider the substantive risk of the guarantor institution's subjective interpretation of the constitutional norms that they're guaranteeing to be a significant risk factor in the operation of the guarantors. Because obviously, when a guarantor institution is promulgated and developed, and once they have once they have the right to interpret the Constitution on certain issues, that gives them a certain Schmittian sense of having the right to declare the exceptions to the constitutional norms that are being questioned, which in the hands of individuals whose commitments to, say, these normative values would be less than, less than substantial, could be an issue. And the third problem was, again, looking at the literature surrounding the guarantor institutions, I've noticed that one of the bigger issues within the functioning of guarantor institutions is coerciveness, or the idea that guarantor institutions, as they are non-elected expert bodies, quite similar to the judiciary in their structure in most cases, have issues in enforcing their judgments, or may have potential issues in enforcing their judgments. And this may be a bit controversial for an audience of legal scholars, but one of these potential solutions to this, which had been actively practiced in Turkey until the legal reforms of 2010, was the military directly acting as a guarantor institution, which again seems undesirable based off of a certain normative commitment to the rule of law and bearing in mind the absence of expertise or perceived absence of expertise in this situation. But this was a phenomenon that was happening in Turkey for the longest of times. I think we could say from 1923 to 2010. And again, while avoiding a normative commitment to a certain set of values, it could definitely be said that they did have a subjective interpretation of the Constitution. They managed to act as a guarantor sufficiently to defend that interpretation of the Constitution.
Thank you. I wish I could come here more often. All the questions are, I'm really enjoying answering the questions, or taking on the questions at least. I'm not sure that the answers are adequately convincing. So you're absolutely right about the need to have specific normative commitments. If we step back from sort of the picture that I have tried to paint for you today, there are many institutions that guarantee different norms in our society. And then, of course, we may agree or disagree with those norms. So we have to then work out, constitutionally speaking, which types of norms, which types of non-self-enforcing constitutional norms guarantor institutions should guarantee. And that's a substantive, normative conversation that one has to take on. And I think bringing in the duty to prevent from international human rights law can help us to map that out a little bit more. But if you look at a constitution as a contested terrain, you can certainly identify different types of guarantor institutions which seek to guarantee different other types of norms. So I agree with that. What do you do when guarantor institutions themselves come up with subjective interpretations of the Constitution, which may be, broadly speaking, unconstitutional? Well, one is you can have the possibility of judicial review. And then we come back to the fact that even, for guarantor institutions to function, the executive, legislature, and the judiciary must function in certain minimal levels. So if you arguably have an independent judiciary that is competent, and if a guarantor institution is going rogue, it may be possible to ensure that there is some course correction. But certainly that is a risk. On the issue of enforcement, I think I didn't answer your question as well on the issue of enforcement. You said these bodies can be toothless. So some of these bodies are toothless, some of them are not. And that again depends on the mandate that the legislature gives them. So my view is that it is okay for some of these commissions to not have full power of enforcing their decisions or recommendations, because the broader society, other constitutional institutions must also collaborate with these bodies. We often think that the law must always work with force. So if the law or a legal institution makes a recommendation, that it must be enforced with a particular kind of force. But what if we imagine a society in which we are also trying to generate a different type of behavioral response to decisions of state institutions? And if that is not received well, if your recommendation is not responded to, that means we have deeper problems in our other institutions. And that is what we need to focus on, rather than trying to get an unelected body of experts trying to force their decision. I'm not sure whether you can understand what I'm trying to get at. I'm trying to suggest that you also need minimal conditions in which within a jurisdiction, other state institutions come to a stage where they at least minimally recognize guarantor institutions. If they don't, this argument cannot stay afloat, I fear. Thank you.
While handing over the mic, let me also ask, you said at the beginning that you had, you're working from practice to theory, and from a global South perspective. My double-pronged question is, are you getting a sense of a new theoretical understanding or perspective or insights coalescing from that approach? And the second question is, have you gotten a sense of what global North polities can learn from the global South perspective and lessons that you're learning?
Should I ask? Thank you. I'll keep it brief to just one question because of time. I was wondering if you see any challenges with describing corruption as a state capture problem. I think I might just be conceptualizing both quite narrowly. But if I can think of examples where we've successfully argued state capture, it's been limited to maybe like a decade. You can usually point to, if not individual government officials, like a smaller group of elected people. Whereas when I think about corruption, particularly in some African countries, it's much more systemic, widespread. I mean, there are governments that are more corrupt than others, but even in the sort of calm political periods, it exists in like the civil service and how agencies and ministries operate. So yeah, I was just wondering if you could say more about that. Thank you.
Thanks. So I'll answer this question first. So the way I see the relationship between corruption and state capture is, I think of one of intensity and spread. As you say, corruption can exist at so many levels and sort of throughout the life of a state, but I do think it can intensify in a way that leads to a condition of state capture. And I think the language of state capture helps us to better articulate the severity of the problem of corruption. I'm also trying to develop an argument to show how state capture is not just about what we see in this moment, but perhaps we can go back in time to see attempts at state capture, even from the early sort of life of the state. I mean, this is, of course, in the Sri Lankan context. So that's about that question. Abadid, your question about practice to theory, do I think I'm developing new theory? I don't see myself as someone who's very good at building theory. But I do think that when we look at the experiences that we have in places like Sri Lanka and other parts of the global south, we tend to come to questions of constitutionalism, institutional design in very different ways. And we emphasize different issues, different concepts. And in that process, I think, I mean, I'm definitely not opposed to the idea that we are developing new theory. It is possible. And I mean, many have claimed that Guarantor Institutions and the Meta Guarantor Institution is contributing to new theorization. And here we are, I mean, I didn't touch on this today. The argument that separation of powers can look different, that it is not just about executive, legislative, or judicial powers, but there is also this idea of a guarantor function, guarantor powers, and perhaps a guarantor branch. But that is work, I think, that is yet to be done, at least as far as my work is concerned. Can the Global North learn from this work? Of course, again, I didn't speak to this. These Global North, Global South are fairly contested categories, very fluid as well. I certainly think the Global North can learn from these issues. And like I said, I began by saying one of the core problems that Sri Lanka has been trying to respond to is the problem of executive aggrandizement. I think I need not say any more about how that can have relevance in other parts of the world. Thank you.
I believe we have time for one more question.
She has one.
Thank you. I kind of just wanted to contribute to the discussion about the legitimacy of guarantor institutions. And I think what you were saying about, because of their function, it's maybe better to have them as like technocratic rather than elected. But I think one of the reasons why they sometimes seem inefficient or toothless is because you have this gap between what the guarantor institution is saying the constitution or the law ensures in a country, and then that compared to what the executive or the legislative even is doing. So I don't know, I was wondering whether you think it's better for guarantor institutions to stick to that ideal, even when there is a gap, a sort of massive gap between that and, you know, the reality that affects how the public view them, versus maybe go with a slightly slower, more gradual approach towards the ideal norm that they're trying to protect, but in a way where the public maybe sees them doing work. Obviously, in that process, you don't want to lose the commitment to the underlying norm, but I do think it's a massive perception issue, especially when you're having like technocratic experts do this. Thank you.
Again, a fantastic question. So I'll try to keep it brief because we have, I think, 4 minutes or so. In a meta guarantor institution designed in the way the Sri Lankan institution has been designed, I think you can have the ideal plus the approach where you try to compromise. So around the table, you have people who with different mandates. So arguably, an independent expert would sit there wanting the ideal outcome. You'll have the leader of the opposition, the prime minister wanting to find different ways of resolving that question or decision. So that process can bring us to a particular place. And I think that is why that design is quite interesting, because it allows for the kind of decision making that you don't see in the executive, judiciary, perhaps even in the legislature. On whether guarantor institutions themselves should hold out the ideal or seek to compromise, of course it varies depending on the question. I tend to be an idealist when it comes to these matters, and I think, again, if you're working in a context where there's a crisis of representation and presumably the executive and the legislature are taking very problematic positions on a given issue, I think there is something very powerful to be seen in a guarantor institution holding out the norm and saying this is the standard, this is what should be. And then the executive and the legislature have often, not so much the judiciary, have to respond to that. Then they are compelled to take a position. And I think that is the kind of push and pull that allows the guarantor function to play out in a meaningful way in society. Thank you.
Thank you so much for your questions and for your engagement. And special thank you to Dinesha for flying halfway across the world to be with us today. There was a recent judgment by the Supreme Court where the court was asked to review a decision of the Constitutional Council, and the court really affirmed the authority of the Constitutional Council. So there is a lot of hope, I think, in this space as we move forward. So feel free to maybe write to Dinesha if you have any questions. We can get her email from her. But yeah, thank you so much, everyone. I hope you have a wonderful Thursday.